It's just after 2 now, so we'll make a start. Well, good afternoon, everyone, and welcome to Doughty Street's Court of Protection case law update with Sophy and Gemma Daly. My name's Amos Waldman. I'm a member of the Court of Protection team, the crime team, and inquests and inquiries team. Just a few housekeeping matters to start off with. It's probably unlikely, but in the event that you are new to Zoom and haven't attended a webinar before, you'll have noticed that your microphones are muted and your video's off. That's just to prevent any interference during the course of the webinar. You'll be able to ask questions. There is a Q&A function at the bottom of your screens. Can I ask you please to use that rather than the raise a hand or chat functions? The panelists will try and deal with as many questions and answers as possible at the end of the webinar. If there are any burning questions during it, I'll try and intervene. If we don't have time for any, please feel free to email the speakers with your questions after the webinar. The session is recorded. A copy of the recording and the slides will be available for you and any colleagues who aren't able to attend. And so I'll pass you over to our first panelist, Sophy Miles.
Good afternoon, everyone. And I'm just going to ask Ray to move the slide along to the first slide of my presentation. Thanks, Ray. So this seminar, the idea of the seminar came from an article written by Gemma, Daly, Mary Rachel McCabe and myself for Legal Action Group on case law in the Court of Protection. And I've given you there the link to the article, which is open access at the moment. Legal Action's making most of its material open access during the course of the pandemic. So a quick plug for anyone who isn't familiar with Legal Action. It's a great way to keep abreast of developments in all areas and a good introduction for those who are new to it. So we thought that much of what we'd be talking about today would be expanding on what we'd said in the article. But in fact, there have been so many developments since we wrote that article that a lot of what we're going to be saying, in fact, isn't new, is going to be new and isn't in the article. We'll be looking at further developments in the Court of Protection, and I'm going to start by talking about a significant case in the Court of Appeal. Ray, can I have the next slide, please? Thank you. So this is the case of local authority and JB. And the first instance judgment was a case before Mrs. Justice Roberts. And essentially the facts were that JB had epilepsy and Asperger's syndrome, and it was believed that he lacked capacity to make a range of decisions. He was also considered to pose a moderate risk of sexual offending. And unsurprisingly, he had a comprehensive care package, and that contained several restrictions. And the point of those restrictions was to prevent disinhibited sexual behaviour towards women. Next slide, please, Ray. And the key question was whether he had capacity to consent to sexual relations, and what was the relevant information that he had to be able to understand, use and weigh in order to make that decision. And in the particular facts of this case, what was obviously going to be important was not could he consent himself, but did he understand that the other person had to also consent, otherwise attempting sexual relations with another person would be liable to breach the criminal law. So at the first instance, the judge held that he did not have to understand, retain, use or weigh that factor, and therefore on the test that the judge at the first instance applied, he had capacity to consent to sexual relations. And in essence, in that first hearing, the judge accepted that to include an understanding of the need for the other party to consent would raise the bar too high in a decision which the courts have said is visceral rather than cerebral. And of course, the key point here is that if you're found to lack capacity to consent to sexual relations, the courts can't sanction any kind of sexual relationship, and therefore you can't lawfully be sexually active. The local authority appealed. Can we have the next slide, please? Thank you. And the judgment of the Court of Appeal was handed down by Lord Justice Baker, but the other judges hearing the case, Lord Justice McFarlane, President of the Family Division, Lord Justice Singh, made up a pretty heavyweight bench. And so it's a very significant decision. And I think it's well worth reading the judgment in full, and it's clear and powerful. And it identifies the need to balance what Lord Justice Baker described as three imperatives. The first is autonomy, and we can see here in the judgment that he makes a very clear link between the Mental Capacity Act and the purpose of the UN Convention on the Rights of Persons with Disabilities. And in the judgment, he references Article 1 of the Convention: promote, protect, ensure the full and equal enjoyment of all human rights and fundamental freedoms by all persons with disabilities, and promote respect for their inherent dignity. The second, protection of the vulnerable. And the third, which becomes very significant in the course of the judgment, the obligation on the Court of Protection to adhere to general principles of law. So that's his starting point. Can I have the next slide, please? Now, Lord Justice Baker then proceeded to do a detailed survey of the case law. And next time anyone is preparing either a letter of instruction or a position statement about sexual relations, that's the place to start. And he started with a pre-MCA decision, ex-City Council and MB. And the wording in that decision is very important. How then is one to assess whether someone has the capacity to consent to sexual relations and the ability to choose whether or not to engage in sexual relations? So that's a two-stage question. Can we have the next slide, please? Lord Justice Baker considered the Court of Appeal's decision in IM and LM and said that, well, the fact that if I include the need to understand the ability that sexual relations must be mutually consensual is not inconsistent with the court's analysis in IM. And he goes on to say, well, giving consent to sexual relations is only part of the decision-making process, and the fundamental decision is whether to engage in sexual relations. And the point that he makes in the judgment is that many of the judgments that we read in the Court of Protection are focusing on consent because they're frequently looking at the risk to someone who is themselves vulnerable to exploitation. But the facts in this case, as he goes on to say, are different. Next slide, please. Here it's JB who wants to initiate sexual relations with women. And therefore it's his judgment to decide how to engage in sexual relations. And what Lord Justice Baker went on to say, crucially, is that it's the question of capacity with regard to sexual relations should normally be assessed by looking at the decision to engage in sexual relations. So importantly, that doesn't mean that the Court of Appeal are arguing for what is called a person-specific decision. They're not looking at who is the prospective partner, they're just looking at a knowledge that that partner can and does consent. Next slide, please. And here's a really important part of the judgment, paragraph 98, looking again at that need for the Court of Protection to sit within a wider legal system. No man is an island. Powerful phrasing. I think we're going to see that paragraph quoted again and again. And I think it's going to be highly relevant in cases where, to the extent where we're considering the extent to which best interest decision making includes the risk that P poses to others. And that is something that many of us will have grappled with in our practice in the Court of Protection. Next slide, please. So to get to the punchline of the judgment, as it were, the relevant information, Lord Justice Baker says, may include, and the may is important, the sexual nature of the act, the mechanics of the act, the fact that the other person must have capacity to consent and does consent, the fact that P can say yes or no, that pregnancy is a reasonably foreseeable consequence of intercourse between a man and a woman, and that there are health risks of STIs, which a condom could reduce. Next slide, please. So the question that we're left with is, well, are these always all going to have to be included? That's a question, the judge said, of considerable importance, but it wasn't actually argued before him, and therefore he thought it would be prudent to refrain from commenting. But in fact, he did comment slightly on this point, and he referred back to his own judgment of TZ back in 2013. Now, in TZ, Mr. Justice Baker, as he then was looking at the capacity to consent to sexual relations in relation to a gay man. And he said, which may seem pretty obvious to most of us, that the information that TZ needed to understand didn't include the risk of pregnancy. So he's already reminded us of that. And we can see that as there's a bit of a pedigree developing for the concept that we tailor the information to P's circumstances. We've got LBTH and NB, where Mr. Justice Hayden held that relevant information should incorporate P's circumstances. And then we've also got B and a local authority, sexual relations, and also internet use and social media use. A guidance on relevant information on social media in particular is to be adapted to the facts of the particular case. So I think this is giving us a little bit of a hint. The direction of travel does seem to be towards tailoring the relevant information required to understand, use, or weigh in relation to engaging in sexual relations. And I think when a case reaches the higher courts and that point is argued, that may well be the direction where we go. Of course, in almost every case where capacity to consent or engage in sexual relations is being considered, the court's also usually being asked to look at contact with others. And we're all familiar with what seems to be something of a fudge, where a court decides that someone has capacity to consent to sexual relations or engage in sexual relations, but lacks capacity to make decisions about their contact with a particular person. And that allows a best interest decision-making process, which may involve restricting the contact and therefore the sexual activity with that particular partner. Can I have the next slide, please? So where does this leave us? Well, first of all, I think it's going to involve the risk to others becoming far more prominent a part in the factual matrix in best interest decision-making. And I think we may see that in Section 16 cases, but I think we may also see that in Dole's assessments, and indeed when we get there, liberty, protection and safeguards assessments. I think also it's likely that we'll see the reassessment of capacities in relation to people who are considered to pose a sexual risk to others. There's a really interesting article by Lorraine Curry that I've given you the link to, and she talks about the opportunity to strike the right balance. She sees the development of this judgment, the focus on engaging in sexual relations as well as consenting to sexual relations, as something that makes it more real, because it recognises that people, whether they have capacity, whether they're whoever they are going to go out and seek to engage in sexual relationships with other people. So I think that's an interesting article to read and have a look at. I suspect that we're going to see an increase in re-ex applications in relation to those who are considered to lack capacity because of their lack of understanding of the need for sex to be consensual. And I think what is so important is that if more people are assessed as lacking capacity, that they are then given support that they need in order to attain capacity if they are able to do so. Next slide, please. So just a couple of other cases very quickly before I hand over to Gemma. RS was a case about capacity to make decisions on residence, care and contact, use of the internet and social media. RS had autism. and he had mild learning disability. He'd had a background of child abuse, and he had a sexual fetish, paraphilic infantilism. This is also known as ABDL, adult baby diaper lovers, and it involves adults role-playing a regression to an infant-like state, and that included the wearing of nappies. And as the court was keen to point out, this isn't unlawful, but it led to risky behaviour. And in this particular case, the RS had contacted people on the internet who turned out to be sexual offenders, and he'd also been financially abused. Can I have the next slide, please? And he was initially assessed by the joint expert, Dr. Lawson, as lacking capacity in all areas, with formative early experiences contributing to this. Dr. Lawson found that the fetish was associated with what he described as, quotes, abnormally impulsive behaviour, and that it might be a consequence of his learning disability and his cognitive impairment. And I found the use of abnormally impulsive behaviour, which comes up quite a few times in the context of his report, quite interesting. And it seems to have a bit of an echo of Section 1 of the Mental Health Act, where learning disability can be classed as a mental disorder for the purpose of the MHA if it's associated with abnormally aggressive or seriously irresponsible conduct. But in fact, Dr. Lawson re-evaluated his report and his opinion. And I think one of the factors seems to be the attendance note of RS's solicitor, who had been to see him and ascertained his thoughts and his wishes and feelings. Can we have the next slide, please? And the expert eventually accepted that RS could, and in fact had been, modifying his impulses, and he was deferring his wishes to meet with those he chats with. And therefore, the doctor, again using that phrase, said, I cannot consider that this impulsive behaviour is abnormally impulsive, but he's just making unwise decisions. He had difficulties with his decision making, but it wasn't clear whether they stemmed from his learning disability or immaturity, psychological makeup, and his sexual desires. So in the end, declarations were refused, but the sort of elephant in the room appeared to be that it wasn't clear whether he had financial capacity or not. The court hadn't been asked to look at that. And there was a suggestion, firstly, that an application might be made in relation to financial capacity. And secondly, there was possible consideration of the inherent jurisdiction. Next slide, please. And the last case that I want to briefly touch on before handing over to Gemma is Health Service Executive of Ireland and Ellen Mead Moorgate. Now, this is an application under Schedule 3 of the Mental Capacity Act, which is one of the sort of lesser known or perhaps lesser used aspects of the MCA. Schedule 3 is one of the cross-border provisions in the MCA, and it allows the court to recognise and indeed enforce orders of foreign courts in relation to those who are habitually resident in another country, but they're in England and Wales. And the courts can disapply that foreign order if there's been a breach of natural justice in getting the order, or if it's felt that it's manifestly contrary to public policy, and various other exclusions as well. Those are the most important ones. SM was 19, she had a serious eating disorder, and she was a ward of the Irish High Court, and she was moved to Springfield University Hospital in southwest London. But things weren't going very well. She was deteriorating, and her consultant was requesting a move as a matter of urgency. The Irish High Court directed a move to Ellen Mead Moorgate Hospital, and the question for the Court of Protection was, are they going to recognise and enforce the order? Can I have the next slide, please? Mr. Justice Hayton accepted that the criteria for recognition and enforcement were met, and that he recognised and enforced the order and authorised SM's move. And one of the reasons I've just flagged this case is that although the law is actually quite technical, SM herself wasn't represented. Now, she was represented in the Irish High Court, and obviously that was the court that was making the order that the COP was being asked to enforce. And previous judgments have said, well, once you're satisfied that the criteria for recognition are met, and it's not manifestly contrary to public policy, then you're who should be working with the grain of the foreign order. Mr. Justice Baker, in a previous case, has said it won't be necessary to join P in a majority of cases. And that was the decision that was taken here. But what Mr. Justice Baker said in HSE and PD back in 2015 was he was looking at the range of options for P that had recently been added to the Court of Protection's rules through what was then Rule 3A, now Rule 1.2. And he noted that the Law Society was at the time considering a scheme of accredited legal representatives. And Mr. Justice Baker said, well, that sounds something that would be appropriate to provide a quick and focused analysis of the criteria in Schedule 3. And he urged the Law Society to create such a panel and said that that could be very useful in these cases in future. So really just flagging this up, we have a range of ALRs. I'm sure there's plenty of ALRs listening today. This seems to me the kind of work that the scheme could well be made use of in. And I do hope that the courts will perhaps be thinking about appointing an ALR in Schedule 3 cases in future. That's all from me at the moment. I'm going to hand over to Gemma. Thank you for listening. I'm sorry if I've overrun very slightly.
Thanks, Sophie. Always a difficult act to follow. So I'm going to take us through a whistle-stop tour of a number of other cases that we've picked out as being hopefully useful. So starting with SF, and this was a case before Mr. Justice Cobb. And the background that you should know about this case is that what had essentially happened is that whilst SF's husband was at work, a man known as Dennis had been visiting the couple's home and what was called taking advantage of her. So Dennis had been advised by the police not to pursue a sexual relationship with SF, as they said it would be unlawful because it didn't appear that she had capacity to consent to sexual relations. And as far as was known at the time of the judgment, he no longer visited SF. But the question came before the court as to whether she did in fact have capacity to make decisions about contact and sexual relations and other matters. And what was agreed between the parties was that she lacked capacity, SF lacked capacity to make decisions about contact with others, except where this related to her husband. So this unique approach of this first person-specific capacity decisions on contact. And Dr. O'Donovan, the psychiatrist in the case, had assessed P as lacking capacity to make decisions about contact with strangers, but having capacity in relation to her husband because of what she called a distinction between episodic memory as opposed to semantic memory. And have a look at paragraph 20 to try and get your head around what that means, because it's not straightforward. But essentially, as I understand it, episodic memory is when you have personal experiences and you remember the time and the situation, whereas semantic memory is more about the feelings attributed and associated with the memory. So with SF, what the expert said was that she would need to have a regular understanding of someone before she would reach a capacitist decision about contact with them. So in relation to her husband, she knew that she had feelings for him, she knew how he made her feel, and she knew if he was in a good or a bad mood. Next slide, please. The doctor had also assessed her as having capacity to consent to sexual relations, despite being vulnerable to sexual exploitation outside of marriage, bearing in mind, of course, that the context is this man, Dennis, who'd been coming to the house. So what the doctor said about SF is quite interesting and perhaps controversial in a way. And the quote's there, and I'm going to read it because it is quite unique. She said that her view that males take the lead when in sexual relationships to decide about sexual relations, and that women do not refuse to have sex with their partners, so these being the views of P, as this would negatively impact on the relationship, indicates that she's aware that she has a choice and has considered the perceived consequences of consent versus refusal. And this, in the context of her marriage, does illustrate a degree of passivity. However, this is not unique to her mental disorder and predates the onset of this. Furthermore, it is common view that is held in various relationships, the expert said. Next slide, please. So this is someone, P was described as passive, apathetic, a biddable woman, and she was said to be happy to be led by her husband. And the court had to consider whether that was because of her innate passivity, because of her personality, or because of and attributable to a disorder of her mind. So there's an exploration and discussion about the causative nexus, which we don't always see. And Mr. Justice Cobb determined that she did have capacity to make these two decisions, so uniquely to decide on contact with her husband and to consent to sexual relations. Next slide, please. So the next case I wanted to talk about, and as I said, it's going to be a whistle-stop tour, is AS. And AS was another decision before Mr. Justice Cobb, actually. And the point I'd like to make just briefly is about the relevant information. So you had a 44-year-old man with a diagnosis of mild learning disability and acquired brain injury who was living in supported accommodation, and he was subject to a community treatment order. The question was whether he had capacity to make decisions as to the litigation, residence, and care. And the court decided that, or accepted the submission from the local authority and the trust, that structure and routine were an integral part of the information relevant to a decision on residence. So the fact that these are the characteristics, structure and routine, that differ between supported and independent living. So it's a small point, there's more discussion in the case, but that's the point that I'm suggesting you take away from it as to the relevant information. Next slide, please. So this case of re A is the P in this case. This was Senior Judge Hilda, and A was 69 years old and had Korsakoff's dementia. Been admitted to hospital, and she was discharged to a care home. And she desperately wanted to return home to her flat where she'd lived for over 20 years. Questions for the court were about capacity to make decisions about residence and care. So quite a familiar scenario for many of us in thinking of Section 21A cases. And Senior Judge Hilda looked at the checklist that we're all familiar with, I'm sure from LBX, of relevant information about residence and relevant information about care. And she also essentially applied the decision of re B of the Court of Appeal, and that being the case about the silos. So Senior Judge Hilda looked at the checklist and noted that what sort of care someone would receive in each placement in broad terms is relevant to decisions about residence. But that there's, sorry, next slide, please. But that there's not necessarily a necessity to understand or to be able to make decisions, capacitous decisions about care to make capacitous decisions about residence. So applying re B, whereas in that case, the first instance decision would have did result essentially in incompatible decisions about capacity. Here it was possible for someone, Judge Hilda said, to have capacity in relation to residence, but to lack capacity in relation to care. And that must be right because of the specific decisions under the MCA and each capacity decision being separate, as long as it doesn't result in this sort of bizarre incompatibility. Next slide, please. Then we've got the case of DA and DJ. So this is the sort of interesting because it's from 2017, but it was only published this year in March so that we could have something to do during lockdown. And it's essentially another judgment on the threshold for Section 48, so interim declarations under the MCA. And the court had to consider the conflicting judgments of Re F and the Wandsworth case before Mr. Justice Hayden. Next slide, please, Ray. And I've set out there, I'm not going to go through it in detail, but the different thresholds. And you'll probably be familiar that Re F set down what is a much lower threshold for engaging the court's jurisdiction under Section 48 than Mr. Justice Hayden did in Wandsworth. So in Wandsworth, there was a focus on P being more at the centre of the capacity evidence, even for the interim declaration stage. Next slide, please. And in DA and DJ, the parties both invited the court to prefer the lower threshold because the risk that otherwise it makes the act unworkable in practice and runs a high risk of imperiling the safety and well-being of those persons whom the act and the judges are charged with protecting. And Mrs. Justice Parker in this case disagreed that P's voice had to be heard in the evidence, so that's what Mr. Justice Hayden had said, and held that a possibility, particularly a serious one, and an unclear situation, which might suggest a serious possibility P lacks capacity, all of those meet the Section 48 test, so quite a low threshold it's suggested in that case. So if you're looking for a case to say the court's jurisdiction is engaged, this is going to be helpful, I'd say. Next slide, please. Moving on to MSP, and this is a decision of Mr. Justice Hayden, and interestingly it was an out-of-hours application which the official solicitor was able for the first time to get involved in and to contribute to, which I think from the judgment was very helpful, it sounds. It's a case that I would encourage you to read the judgment because it is very moving, and it's a case all about personal autonomy and P's wishes and feelings. He had a 34-year-old man with a complicated abdominal history. He was sedated and ventilated following a stoma operation. And the question was whether the trust should continue to provide ITU support or withdraw treatment for him. And the court focused on his wishes and feelings and his autonomy. Next slide, please. And there's some really strong quotes and discussion in this case about what P wanted. And P had essentially, he'd had a stoma before and he'd utterly loathed life with a stoma. He'd had a reversal in May 2020, but sadly that he'd developed significant abdominal pain and sepsis, which meant it was life-threatening and he needed a new operation for a stoma. And the doctors said he needed that immediately. He consented to that stoma being inserted and to that operation. And this, as you see from the judgment, was quite unusual because he'd so clearly wanted the stoma reversed. He had, for a very long time, told his doctors, and there were 3 doctors involved, that he didn't want the stoma. He didn't want to live life with that in place. And so those doctors were surprised that he had in fact consented to another doctor to having the operation. It was inconsistent with everything he'd said to his family about the life he wanted to lead, not wanting to have to live with a stoma in place. And it was also inconsistent with what I've put in inverted commas as an advance directive, which he'd prepared in February. And that's because that wasn't an advance decision in terms of being procedurally compliant. So it didn't have that effect, but it was used to consider his wishes and feelings. And this was someone, and I think it was really important to understand, he'd been very private about his stoma. He'd only told 3 people, his parents and his stepsister. He hadn't even told his grandmother. And the doctor who had gained his consent to have the operation had been optimistic that it could potentially be reversed at that time. Next slide, please. Sadly, that wasn't the case. And he was at the point of the judgment ventilated and sedated. So the court considered, Mr. Justice Hayden went through the fact that perhaps many people would be able to live and would be able to accommodate the difficulties of something such as having a stoma, but this was simply not the case for MSP. So the judgment makes really clear that we're thinking about specific individuals and focused, as it is in the MCA, on wishes and feelings and personal autonomy, not just about what the court and other professionals might think is reasonable for someone to do. So he'd been described by his sister, this P, MSP, as knowing he was good looking, and there's discussion of him buying expensive sunglasses. And he may perhaps have been described as a bit vain by his sister, but actually the court said that it's not mere vanity, but it was a reflection of his determination to conceal the impoverishment of his health and to present himself to the world as competent and active. And he'd set out in his detailed advance directive, which, as I said, wasn't a effective advance decision, but he'd set out in there that he didn't want any operation that would include that would reduce the likelihood of a reversal of a stoma to 50% or less. And he'd also set out in that advance directive loads of really specific and careful details about other things that he wouldn't want and he wouldn't accept. And he'd even set out, for example, what music he'd like if he was in a coma again, having previously been in ICU. So it's a very careful and clearly well thought out expression of P's wishes when he had capacity. Next slide, please. And the court said he had come to a clear and entirely settled decision that he was not prepared to contemplate life with a stoma or indeed any significant life-changing disability. And this is important. It is not for me or indeed anybody else to critique those views or beliefs, but merely to identify them. They are a facet of MSP's broader personality, the expression of which is integral to his own personal autonomy. I think that's very moving and very important. But also when we're making, if you've got a case where you have to emphasize personal autonomy, I think there's a lot of quotes, and this may well be one of them, that we'll probably be referring to in our submissions. Next slide, please. The question was ultimately whether it was in his best interest for artificial nutrition and hydration to be withdrawn. So as I said, the advance directive wasn't a binding advance decision, but it represented his clear expression of wishes and feelings, and the court heard evidence from his family as well and through consultants as to what his wishes and feelings had been. His consent to the stoma was not necessarily inconsistent with the entirety of the other evidence because he'd been told that it was potentially reversible at that time. And the court considered that if the doctor had in fact been pessimistic about the prospects of reversal, he would have rejected the procedure and chosen to die. But importantly, section 4.5 of the MCA, of course, doesn't allow the court to correct the error by bringing about his death, not brining as it says on the slides. And the court was satisfied that P would unhesitatingly reject the parenteral feeding. And in the exercise of his personal autonomy, he's entitled to take that decision, which this court is required to and does respect. So ultimately, the court authorised the plan as proposed by the trust. So a very important judgment about personal autonomy. And the final sentence there, this is an important facet of personal autonomy which requires to be guarded every bit as jealously for the incapacitus as for the capacitus. As I said, some very important comments in that case. Next slide, please. PB. So this is a case about alcohol-related brain damage or about alcoholism and unwise versus incapacitous decisions. So a 52-year-old man with alcohol-related brain damage and dissocial personality disorder. And the first instance judge, I think it was District Judge Eldergill, had referred the case to Mr. Justice Hayden for two key questions to be asked. And those questions were firstly, how should the court approach the assessment of capacity of individuals who are alcohol dependent? And secondly, whether or in what circumstances the Mental Capacity Act should be used coercively to prevent people who are alcohol dependent from gaining access to alcohol. And the answer to the first question, well, it wasn't really answered because the focus instead in the case was on capacity to make decisions regarding residents and the relevance of alcohol within the context of those residents' decisions. And the second question didn't ultimately become relevant for the court, but Mr. Justice Hayden was critical of the term coercion and said that coercion has no place in the course of protection. Next slide, please. So in the report from Dr. Costa-Freda, the expert in the case, the psychiatrist, had initially assessed PB as having capacity to make decisions regarding care, residents, and fluctuating capacity, interestingly, regarding litigation, and then subsequently revised the opinion. And it was said that it was almost certain that if he started drinking again, he would lose control and trigger the cycle of homelessness, intoxication and withdrawals, self-neglect and hospitalizations, likely ultimately to cause his death. So not an unfamiliar scenario that we see in COP cases with alcoholism. Next slide. And it was said that P seriously overestimated his ability to keep his alcohol dependence under control. But in the first reports, at the point when the doctor had assessed P as having capacity, commented, firstly, minimizations, rationalizations, and justifications, despite all evidence to the contrary, are typical of people with substance dependence who are not generally considered to lack capacity. Secondly, P did not exclude the possibility he could die and defended his decision to continue drinking on grounds of autonomy and fatalism, so thinking of the difference between the unwise decision-making and incapacitous decision-making. And thirdly, his answers showed sufficient understanding and acceptance of the risks to his health and well-being that would result from a decision to go back to drinking. The doctor then revised the opinion after there'd been a trial, and ultimately P during the trial had consumed more alcohol than a moderate amount, and the doctor had considered that to mean that actually he lacked capacity in relation to residence and care. And Mr. Justice Hayden, in regards to that revised opinion, and the revised opinion essentially said that what P hadn't accepted was that it was beyond doubt that he was unable to control his drinking, so that he's in fact certain that he will continue to drink to excess if he's not supervised. So that's what P was expected to understand and appreciate according to the doctor. And Mr. Justice Hayden said essentially that's too high a threshold. The effect of such a test would be eroding very significantly the space between a decision which is unwise and one which an individual does not have the capacity to take. So the focus was on the reasonably foreseeable consequences of deciding one way or another. And P was able, it was said, to see those reasonably foreseeable consequences of his decision. And whilst his plan as to what he would do may not have been sustainable long term, that does not permit, the court said, an inference that he is unable to foresee the consequences of drinking to excess on the sustainability of the placement. So whilst the court finding that he had capacity to make residence decisions for himself meant that it may hasten his death, PB, like any of us, is entitled to make bad decisions if he chooses to do so. Again, an important comments and judgment about autonomy and capacitous decision making. Next slide, please. So I'm going to very quickly just talk about MC. So this was a judgment of Mr. Justice Cohen. And the interesting point here, this is a stem cell donation case, which you may have heard about. Essentially, the trust had applied for the court's consent for the harvesting of peripheral blood stem cells, so essentially stem cell donation for P's mother, who had chronic leukemia. So there was not going to be any physical benefit to P. It was all about whether it would be in P's best interests to donate or to have the procedure to donate these blood stem cells for her mother. And she lacked capacity to decide on that proposed procedure. The court considered the side effects to P as part of the best interest analysis, which were relatively minor, but not risk-free. And P didn't understand the details of what the procedure involved, but she had a clear wish that if she wanted to help her mother, she would. So the court considered that whilst there was no physical benefit to her, there was a clear emotional, social and psychological benefit of her mother's life being extended. And she lived with her parents, she had a loving relationship with her parents. So I think that's completely understandable, the benefit to P of her mother who's caring for her and living with her, having her life extended by that donation. So it was considered to be overwhelmingly in MC's best interest as much as her mother's. But importantly, of course, the court was focusing on P's best interest, not the mum's. Next slide, please. So I knew I'd run out of time, so I've just quickly put reference to the other cases that are in the lag update that Sophie referred to. So they're on the slides, so if you want to have a look at the slides, you'll have them. Just to flag what's there, there's the case of AF, which talks about the intrinsic quality of life, and it's a clinically assisted nutrition and hydration removal case. You've got RE-Z, which is about intrauterine contraceptive device at the time of a C-section. RE-D, I think, Sophie, this is your case, wasn't it? Yeah, you're nodding. This is the permission threshold being the same as for judicial reviews. And then habitual residence. So this is the second case, QD, of the family or the children who brought their their dad to the UK from Spain. So all about the deadlock with the British and the Spanish jurisdiction. And then MPZ, which is a case about where P's failure to believe was considered to be a failure to understand. And that's quite interesting. So I'd flag that as one to definitely have a look at. Next slide, please. And I think Sophie.
Yep. Yeah, this is finally hot off the press judgment that I first saw this morning. Those of you who spend time on Twitter may be familiar with it because it's been very closely followed by the Open Justice Court of Protection project, and there's been some really quite interesting writing and commentary on the case as it's unfolded in real time by Celia Kitzinger and various other people who've been observing it. And it relates to a young Palestinian man who had PTSD and depression consequent to very serious trauma he'd experienced growing up. He came to the UK, he was placed with foster parents, he had a very close, warm, long-lasting relationship with those foster parents. But the Home Office determined that he was older than he said that he was, and changed his date of birth. And this triggered a really traumatic reaction, which led to him refusing nutrition and hydration. He was eventually detained under Section 3 of the Mental Health Act. And the purpose of that was for him to have nutrition and hydration through a nasogastric tube He absolutely couldn't tolerate that. Section 3 order was rescinded, and the question is, well, what happens now? So the trust went to the Court of Protection. The court found, on a very fine balance, that he lacked capacity to make decisions about nutrition and hydration. He could weigh facets of it, but he couldn't weigh up the global decision. So again, that's another of these cases where the court's looking at the difference between a micro decision and a macro decision, just expressing it, I think, in a slightly different way. And Mr. Justice Hayden approved a plan, but it was one where WA had the right to say no. It's, again, like many of the other cases that we've been looking at today, it's really worth reading. It gets a very powerful, very moving judgment. And there are three things that I think are important to take away from it. So the first is that throughout the case, WA instructed his legal team directly, and Mr. Justice Hayden was entirely satisfied that he had capacity to conduct the proceedings, but his capacity to make the substantive decision was on a knife edge, and in the end the judge concluded that he lacked that subject matter capacity. So one of those quite unusual cases where P has capacity to conduct the proceedings but not to make the main decision. The second point that I think is really interesting to take away is about, well, what happens when capacity is really finely balanced? WA's counsel argued that that meant that you apply the presumption of capacity. You tip the balance into judging capacity, that the person has capacity. But the judge didn't accept that. And what he said was that this, even if capacity is on a knife edge, that doesn't absolve the court from its duty rigorously to analyse the evidence. The presumption of capacity just places the burden of proof on the shoulders of the applicants. But even when it's finely balanced, the court still has to weigh it up really carefully, and it's the decision of the court which side of the line it goes. And finally, the sort of holistic nature of the best interest test as it's applied in this case. I've put one of the perhaps quite important comments towards the end of the judgment. Loss of capacity doesn't override respect for personal autonomy. Protecting the autonomy of the incapacitors is every bit as important as protecting the autonomy of the capacitors. And of course, we've heard that phrase over and over again, I think. And I think there's a real sense of the importance of making sure that the finding of a lack of capacity doesn't mean there's a blank check. And it's what is quite interesting is that, as I said, the plan that's actually adopted in this case was one that he would not be coerced to follow. So that's, I think, all we wanted to say in terms of specific cases, and it has been something of a whistle-stop tour. I'm just wondering if anyone's got any questions. I'm just going to have a look in the question box. And at the moment, it doesn't look like we've got any questions from our audience, but I'm just wondering, Gemma and Amos, is there anything either of you want to flag up that perhaps has come out, that perhaps hasn't quite come out in our discussions so far?
Well, thank you. Firstly, thank you very much, Sophie and Gemma, for that fascinating and extremely useful trawl through the recent cases, the Court of Protection being extremely busy during the lockdown period. Just one thing I was thinking of really, a lot of these cases, whether it's JB, Tower Hamlets and A and KF and Z, which Gemma, I think, was up on one of the slides that you put up in relation to IUDs. A lot of the cases relate to information relevant to a decision. And certainly currently there are lots of decisions being made in relation to COVID measures, particularly social distancing and masks. And so it just occurred to me really what the relevant information is in relation to those matters and to complying with COVID restrictions.
That is a really good question, and a difficult question, I think, particularly because, of course, that information is changing all the time. The guidance is changing fairly regularly, and the most recent piece of guidance, or indeed effectively regulation, is wearing a mask in a shop. So I'm not aware yet of any judgments where the court has actually set out what the relevant information that P is required to understand, use or weigh and retain is. I'm certainly aware of some cases that are making their way through the courts, and if anyone in our audience has any update on that, please do just pop it in the Q&A, because I'd be personally very interested to hear, or send us an email. But I think I would hope firstly that the courts would not want to set the bar too high. And one of the things that might be interesting would be to go back to some of the guidance that the government has given about the use of the MCA and DOLs in best interest decision making. And they've set out some of the relevant information that you might take into account as relevant circumstances. So that is COVID-19 is a very contagious disease. In many people, it's mild, but it can be fatal in others. There's currently no vaccine. There's currently no specific treatment. And that some social distancing measures can reduce the possibility of infection. So, I mean, I would think, well, that would probably fits quite neatly into a list of information that would be relevant to the decision. As I said, if anyone is aware of anything, any actual judgments that have been made or that are on the way, I'd be really interested to hear. And I'm just going to have a look at our Q&A, which is still free, so it doesn't look like anyone's had any.
I think there is a question now.
Okay.
Oh, it's in the chat box actually.
All right. Okay. Let me have a look.
From Peter Edwards, and he says, "Do you think the risk of death in a care home tilts the balance towards a move home? Is it a relevant factor?"
I'm sure that would be a relevant factor. I think that the court should be scrutinising this question really carefully, and as yet, again, I'm not aware of a case where that decision has had to be made. Certainly not in a reported judgment, and it's going to depend on the factual basis in each case. So we know now, for example, that fatality rates or infection rates seem to be higher in large care homes. That might be a factor that the court wants to take into account, but I hope the court would also want to take into account what measures the home is putting in place. Have they had any cases so far? What are they actually doing about it? What is the risk of management process? Gemma, do you want to say anything more about that?
I was just going to add, I think it's really important as well to think what the options are and what the reality is if P is not in a care home. So are they going to be having different carers coming in every day at home? What are the risk assessments for that care agency in terms of PPE and preventing the risk of COVID at home? Or are they going to be living, for example, with a family member and they're all going to be shielding still potentially or having very limited contact? So I think it depends on what the other options are, and it may be, in my view, it may be the automatic thought to think, can't be in a care home, it's got to be in everyone's best interest not to be in a care home because of the risk and because of the statistics we've seen. But I'm not convinced that that is the case. And as Sophie said, I think it will depend on the specific circumstances and what the other options are and the risks involved in the alternatives.
Yeah, I mean, I agree. I've just had a question about the WA case, asking if there's any sort of articles that we would recommend for that. I haven't seen any yet, but I would look on Twitter and I would look at the Court of Protection Open Justice Project, because they've been covering it quite extensively, and I'm sure there'll be plenty there if you have a look at it. Now, have we got any other questions or chat comments? Because we're getting, I'm afraid, quite close. Yes, I think we might have. Let's see. No, I can't see any further questions. Amos, have we got anything else?
I can't see anything, no. But again, I certainly recommend the Open Justice.
There is one,
there is one reporting in relation to the WA case. Certainly interesting insofar as there are lots of other people, other observers. So it's interesting hearing their views. There is another question.
Yeah. So how far do you think the court's reluctance to apply a person-specific test for capacity relations regarding sexual relations is rooted in a reluctance to be involved in private life to an impractical or overly intrusive degree? Well, I think that's very much the point that the courts have been making. And when you go back to the case of IM in the Court of Appeal in 2014, where the Court of Appeal was squarely looking at, is this a person-specific test? Are we looking at the characteristics of a proposed partner? That feature, that need to avoid as much intrusion, and also to avoid an unmanageable situation where a local authority would have to assess every proposed partner for P and assess their capacity in relation to each proposed partner, was going to simply be unworkable. So the aim of having the very low bar, the standardized test, seemed to be to try and increase P's autonomy and to try and reduce the number of people who were found to lack capacity. But then the tension is, well, is that unfair? And does the tailored approach actually provide a better and a fairer approach in an individual case? I hope that's helpful. Anything, Gemma, or Amos, either of you wanted to say about that?
I was going to add, and I know you mentioned, Sophie, about when someone's assessed as having capacity to make decisions about contact, but lacking capacity in relation to sex. But if you look at the SF case, I mean, Pete only had capacity in relation to her husband.
Yeah,
it's so clear that that is just about her being able to have sex with her husband and not someone else who's coming in and taking advantage, as the phrase being used in the case. So if there's not a case that, I mean, that is the case to me, that is about person-specific sex, essentially. It's quite difficult, I think, to see it in any other way, but it's a way of getting around the difficulty, and that was very specific to that individual, I think.
Yeah, I agree. Now, any other? I can't see
any more questions.
Questions?
We might be right in the hour. Perfect.
Yeah. Well. Yeah. So just an upcoming seminar then on the 23rd of July on seeking damages under the Equality Act, Human Rights Act, and in negligence in housing. So that's one for the diary. More information available on the website, as is another announcement relating to a recent recruit for the Court of Protection team, Leonie Hurst. So thank you very much all for attending. Hope you have a great day.
Thank you.
Thank you. Thanks, everyone.
Thank you. Bye, everyone.
Bye.